But as your risk management company, these are guidelines that we are encouraging you to follow. Okay, 1, BRE licensing number on everything. If you have your name out there, you have your license number on it. The BRE is looking for people that are not putting their license number on their communications. Text messaging, okay? On your text messaging, you should have your name and your license number on your responses. So if an agent is writing to you about a transaction, go into your settings, have your signature line, have your name, and have your license number on it. Your social media pages. Some agents say, I have a personal and I have a professional, and let's be honest, they're going to cross at some point in time. If your name is there, your license number is there. So when you're working with your sellers, ask your sellers, has your home been featured in any kind of advertising, commercial, movie, or TV? Some people will look at that and think, oh, awesome, all right. Others would be like, hey, I don't want the notoriety that would be associated with that. So make sure you're talking to your sellers and you're asking your sellers about their houses. Now, I always talk about disclose, and disclose again. I want to talk about that again just a little bit. When you're meeting with your sellers, get to know your sellers. Sit down with them. Ask them the questions about the house. You can sell a house in any condition. You can have a house that is full of feral cats, and you're going to find the crazy cat lady that thinks it's perfect. So let your clients know, hey, we can sell a house in any condition. The most important thing that we do, though, is that we disclose everything to the buyer. And you as the agents, if you know it, you disclose it. You do not hold back on your disclosures. That is really, really important. The biggest, actually 95% of my cases are about non-disclosure. It's huge. Ask your sellers questions like, what do they want to keep with the property? Well, that chandelier, that's a beautiful chandelier. Well, yes, that was my grandmother's. It's a family heirloom. Are you going to take that with you? Yes, I'm taking it with me. It's mine. Okay, why don't we take that down and get a new one from Home Depot and put that up there during the listing? Window coverings. Those items stay with the house. In-ground yard fixtures, the lighting, the barbecues, the backyard patio barbecues that are bolted in, things like that, they stay with the property. But the seller can exclude them from the listing. They can. But ask your sellers about that, okay? Okay, rent control. Another hot issue down here right now. If you have buyers that are looking at investment properties, and make sure that, and they're saying, hey, I don't want rent control. I'm dealing with 3 cases right now. Make sure the properties are not in rent control areas. Okay, and don't just trust the MLS, please. MLS is deemed reliable but not guaranteed. Ask the listing agent to confirm for you that the property is not in rent control. Okay, disclosure timelines. Get them done right away. Add addendums if something new happens during escrow. Okay? I don't care if it's the day before. I don't care if it's an hour before. I don't care if it's a half an hour before. 5 minutes before. Anything happens during escrow, you make sure that the other side knows what's going on in writing. And do not trust, I don't care who the other agent is. I don't care if it is your sister, your brother, your mother, or your father. If they tell you something verbally that they're going to do, like, I'll remove the contingencies. Don't worry, it's on its way, it's on its way. And then you go to your client, oh yeah, they're removing the contingencies. And guess what? You never get it in writing. And guess what? The escrow gets canceled. And the seller says, well, I want that deposit. They removed their contingencies. You have to say, I never got it in writing. Always get it in writing. I tell people all the time, verbal schmerble. I don't care what somebody verbally tells you. Get it in writing. That is what CAR tells you. Always make sure that you're following the timelines and that you are getting everything signed off. Okay, questions in regards to that? No? Okay. Do not make promises about deposits. Okay? I mediate deposit disputes. It's part of your coverage through RERM. Now, I have agents I get on the phone with the buyer because the escrow is dead. Basically, there's no heartbeat in it. All that's left is the deposit dispute. I get on the phone with the buyer and the buyer says, look, my agent told me that I'm getting my deposit back because I didn't remove those contingencies. So why am I not getting the check from my realtor? Okay. The reason is because the money is being held in an escrow account. And there's only two things that can get the money out of escrow. One is a cancellation signed by the buyer and seller, or two is a civil judgment. Money can sit in escrow forever. It can be eventually taken over by the state, okay? So, in regards to deposits, make sure your buyer knows, okay, this money is going into an escrow account. We have our 17 days to investigate the property, to make sure that you've had your inspections and all of those things. And then if you decide that you don't want the property, we can cancel and we will send a request for cancellation over to the seller explaining why. Okay, but do not tell your clients you're guaranteed to get the deposit back because you cannot guarantee that.
Question, sorry. On the RPA paragraph 6, usually we put the EMG will be paid to the buyer within the contingency period without the seller approval. Does that help?
It does help. Anything helps. It does. Okay? But still, if it's an independent escrow company, the independent escrow company is going to say, I need the buyer and seller's signature. I have to have it.
Okay.
So, but if you do have a deposit dispute, turn it over to us. We will mediate that deposit dispute for you. Our mediators are not attorneys. I have lots of attorneys available to answer all of your questions, handle your legal defense, which is something that I'm going to discuss the next time I'm down here, and I'll put on a full PowerPoint presentation and go over all the bells and whistles of the benefits. So, yes.
Sorry, this is going back to the disclosure.
Yes.
Do you have to give the new, like you're in escrow, so they did a home inspection.
Mm-hmm.
So now you have a new buyer, you have to give that buyer the old inspection?
I would always recommend to do that.
Okay.
Absolutely.
If the seller refuses to do it, like, because I recommend it too, but they're like, no, I think they should just get their own home inspection.
Okay.
So,
You can tell your seller this. If there is something in this home inspection that is not disclosed to the buyer and it comes up after the close of escrow, the buyer could claim that you did not disclose it to him. That's why we're recommending that you give this buyer a copy of that and have the buyer sign it. Okay? And if the seller does any repairs to the property during the escrow period, well, if they've done any repairs at all, you always disclose all of that. But if they've done any repairs to the property, especially during escrow, you make sure the buyer sees the scope of that work and acknowledges it in writing. Any other questions? Rudy? Questions? No? Yes.
If escrow cancels and escrow company charges money, is there any way we can fight that?
It depends on the escrow company and it depends on their policies and procedures.
If they never sign the escrow instruction, that's okay, right?
They never opened escrow?
They never signed escrow instruction. So escrow open, instruction never been signed and canceled.
They can request that. We can try to mediate that out. We can ask for anything in mediation, just so you know. You know, they can say, hey, I never opened escrow. All I did was deposit the check. They never sent out instructions. They never sent out anything. I don't feel that I should have to pay the $300, $400, $500 escrow fee.